Good morning, everyone, and thank you for having me. Thank you for the invitation. I'm Diána. I'm an attorney and a member of the Hungarian Blockchain Association and the head of the legal working group of the Blockchain Coalition. It means I have several experience from the market side as a practicing attorney and from the regulatory side, maybe for the last 7 years. So, as Attila mentioned, we're living in a very exciting times from a legal point of view and from the digital transformation. And as a forward for my presentation, today morning we are in the asset panel, and the key question is not how crypto works, I think, from this view, but how access to the asset is structured. From an asset perspective, regulation doesn't just define legality, it defines liquidity. And I think it's very important to stress that to crypto, liquidity and access to assets is a very important question. Seen through an asset lens, the Hungarian MiCa case, which I will present to you today, is not about crypto, it is about who can realistically hold and trade and move the asset. Today I speak about the implement of MiCa in the Hungarian legal environment and more specifically about where national implementation maybe collide with the EU level harmonization. There are several interesting developments happening in the last few weeks, so it's a very good timing that we can talk about it today. When the law is boring, it usually means something positive. It means it's predictable, it's harmonized, and it's safe. So when regulation suddenly becomes interesting again, lawyers should pay attention, I think. MiCa was designed a single, directly applicable regulatory framework for crypto assets across the EU. Its core promise, its legal certainty, it means one license, one rule book, one supervisory logic. It meant to change the fragmented and parallel regulation systems across the EU. In simple terms, once a crypto asset service provider is authorized in one of the member states, it is trusted to operate under, of course, supervision across the European Union. So you don't have to apply licenses again and again and again, passporting across member states working and with ongoing oversight by regulators. However, Hungary has become an interesting and somewhat controversial test case because its national implementation raises the question: how far can a member state go in its own regulatory sovereignty before it collides with the EU harmonizing? This is not just a theoretical issue, it already triggered an infringement procedure by the European Commission, of that I will speak later. And this makes Hungary a very practical case study for lawyers and compliance professionals. I promise this will not be a deep dive in technical issues, although I like that side of blockchain and crypto. Instead, I want to walk you through the regulatory logic, because once you see the logic from both sides, I think the legal tension becomes almost self-evident. Let me briefly recap again what MiCa actually requires, because this is key to understanding the conflict. MiCa establishes a fully harmonized authorization regime for crypto asset service providers, CASPs. Once a provider is authorized in one member state, as I mentioned, it can passport its services across the EU. More importantly, MiCa follows a maximum harmonization logic. That means member states are not free to add extra licensing, approval, or validation regimes unless MiCa explicitly allows it. This is a crucial point. MiCa doesn't aim to create a minimum standard. It aims to replace fragmented national regimes with a single one, because MiCa is one of the flagship of the Hungarian single digital market. So the baseline expectation is simple. National law should enable MiCa, not supplement it with parallel systems again. MiCa regulates at entity level. MiCa assumes that if the entity is properly authorized and supervised, we do not need to stop every transaction along the way. In one sentence, MiCa regulates who you are, not everything what you do, with the reason, of course. About Hungary's national approach. Hungary chose a rather distinctive approach in one legal aspect. Alongside aligning its laws with MiCa, Hungary introduced an additional exchange validation mechanism. It means under this system, crypto to crypto and crypto to fiat transactions require validation through a designated authority. It's not another crypto asset provider, it is the validating service provider. What makes this particularly striking is that failure to comply doesn't only trigger administrative consequences, but may also lead to criminal liability. It means the following criminal penalties: carrying out exchange services without these validation systems, or using unauthorized services by users, and this is very important to stress, can lead to criminal charges. Hungary chose to enter into its legal system the amendment of the Act of Criminal Code sooner than before the validation service provider can enter into the market. So it meant a very lot of market uncertainties. So again, MiCa regulates who you are. The Hungarian validator regulates what you do, transaction by transaction. It means before certain crypto transactions executed, they must pass through a validator. So it presents a third-party player into the system. The validator checks compliance before execution. If you bypass this step, it can carry criminal consequences. So it not depends on the result of the validation procedure. This step means the misstep of this step can carry criminal consequences with its own. So we can see two different regulatory philosophies, I think, basically the same goal but different method. MiCa trusts regulated entities and supervise continuously. The Hungarian approach is verify individual transactions before execution, and it results in compliance pathways become significantly narrower. What the validator actually does. To understand the Hungarian implementation, it is important to clarify what the so-called validator actually does and what it doesn't do. Under Hungarian law, the validator is not a supervisor and not a licensing authority in the MiCa sense. So a dual structure is in place, but the Hungarian Central Bank is still the supervisor and the licensing authority for all of the crypto service providers. The STFH, SARA, the Supervisory Authority for Regulatory Affairs, regulates in detail the licensing and the registration procedure of validation service providers. During the validation process, the validator analyzes the blockchain transaction history and network patterns associated with the designated crypto asset addresses. The outcome of this analysis is a consolidated compliance statement, which is compulsory, providing an overall assessment of the risk environment of the examined transaction. The service doesn't constitute consumer identification, source of funds verification, or a substitute for the service provider's own AML or internal control procedures. So it is very important to understand that this process, it doesn't decide instead of the service provider, and it doesn't replace the AML requirements. It only it's another plus layer. Validation is a risk analyzing service, basically, based on an on-chain data which serves to identify and assess compliance and AML risk related to crypto asset transactions. As a result, the validator issues a compliance statement, as I mentioned, and the crypto asset address is examined. It is very important to understand that the examination is based solely on publicly available blockchain data using an objective methodology. I looked after this methodology, what the validator would do, and validation is always carried out by querying multiple databases, performing a detailed risk analysis. The compliance statement classifies the transactions into one of the three categories. The risk is acceptable, it requires increased attention, or high risk, it means increased caution or rejection. The examination methodology uses detailed exploration of the previous route of the crypto asset. It's backward tracing, the analysis of the network behavior and connections of the receiving address. It's called forward tracing, and the examination of cluster and entity relationships and comparison with several international risk databases. So it could be a bit technical, but I'm finished with it now. So you can see it layers another risk analysis procedure parallel with the EU AML framework. Hungary's legal reasoning behind this validation is the exact same. That is just an AML tool, and it strengthens protection. The argument can be true, but it can be legally fragile from the EU side. MiCa already integrates AML considerations through alignment with the EU AML framework. Introducing transaction-level validation with criminal consequences goes beyond functional equivalence and into parallel regulation again, which MiCa was meant to eliminate. And I must mention the fee of this transaction. It's 5,000 forints plus VAT. It's around 13 euros plus VAT, I think, per transaction. So we can go. What doesn't fall under the validator regime? Personal use or own wallets. Conversions where a natural person transfers or exchanges their own crypto assets into other crypto assets exclusively for their own non-commercial purposes. Or non-regular or non-commercial transactions, or transactions done without a fee. It's a very important distinction. Crypto asset conversions that are not provided on a regular basis, or those that are conducted without consideration. I think these exclusions exist in theory and in practice, but the boundaries between regulated and not regulated activity is not always so clear. Decentralized exchanges also falls under exemption. Transactions executed in a truly DeFi manner, particularly those utilizing smart contracts, are under exemption. And one other interesting detail, the covert intelligence activities. It means transactions conducted by authorized authorities for specific covert intelligence purposes is also exempt under the validating regime. So what did the Commission do? In response to this national approach, the European Commission opened an infringement procedure against Hungary a few weeks ago, so it's a very fresh development. The Commission position is relatively clear. MiCa doesn't foresee transaction-level validation systems, and it doesn't authorize its member states to introduce additional criminal sanctions. The concern is not enforcement intensity, it is structural incompatibility with MiCa. This legal tension arises only when full EU harmonization is chosen as the regulatory model. MiCa deliberately narrows national discretion and that choice has legal consequences. For market participants, the current situation is highly uncomfortable. The infringement procedure doesn't suspend Hungarian law, so CASPs operating in Hungary are effectively facing dual compliance obligations. Combined it with a slow initial registration of validators, it was a very gray legal area, almost full of the last year. And this creates legal risk. Some providers have already restricted or suspended services in Hungary, and I think it triggered the Commission to quicken up the infringement procedure or start it at all. For lawyers and compliance advisors, this means advising in a moving legal environment, and it means regulatory risk analysis. And what does it mean for competition? When regulation produces a single compliance pathway, competition law questions inevitably arises. Even if unintentionally, regulation can create de facto barriers to entry, which EU law traditionally treats with caution. But another interesting development happened, and this is a very fresh news because it's from last week. Bitpanda, the Austrian crypto service provider, is now the first and currently only crypto broker fully compliant with Hungarian crypto asset regulations. This means you can continue using Bitpanda without interruption to sign up, deposit, trade, and invest. The Bitpanda partners with the sole authorized validator in Hungary. So it complies with the EU and the Hungarian legal framework as well. It again, the question arises: compliance through a single authorized validator raises questions of market access, proportionality, and de facto exclusivity. From an EU law's perspective, the distinction matters. If compliance is only realistically achievable through a single authorized channel, as I mentioned, the issue shifts from legal possibility to structural market distortion, and I think the Commission will examine it as well. To conclude, there are three key takeaways from this situation. First, MiCa significantly limits national discretion. Implementation doesn't mean reinvention. Second, the Hungarian case is not just local, it may become an EU-wide precedent for how strictly the Commission protects MiCa harmonization model. Third, for lawyers and practitioners, the most important task right now is continuous monitoring of legislative amendments, enforcement practice, and commercial guidance, and maybe Hungary's answer, which is obligated in 2 months. This Hungarian case invites us to reflect on where implementation ends and fragmentation begins, because harmonization is not only about having common rules, I think. It's about ensuring that everyone can realistically enter the system those rules create. Thank you for your attention.